Can you see and hear us?
I can, thank you.
Before we start, two things. I understand that the live link for those with login details is working, hence we can see and hear you, and other people who have those login details will be able to access this live feed. But the YouTube link is not working at the present time. It's been your practice in the past, I think, to continue to sit, because either the YouTube link will be restored and a recording of now will be available, or people can read the transcript.
Yeah.
And then secondly, can I say thank you to David Emwright, who gave me a lift to the station this morning. As you know, he's a partner at Howe & Co., represents many sub-postmasters here, and happens to catch the same train as me, and he's enabled us to start nearly on time this morning.
I'm very glad to hear that all participants in the inquiry are cooperating at all levels, Mr. Beer.
Thank you very much, sir. Good morning, Mr. Atkinson.
Morning.
Can we pick up topic 8, please?
Yes.
The topic we were about to move to, which is cross-disclosure of Horizon issues. Can we turn, please, to page 239 of your second report? And paragraph, I'll just wait for that to come up on the screen. Page 239. At page paragraph 668, you say, as time passed, the number of cases where Horizon issues were being raised proliferated, and the need for cross-disclosure between them should have become all too obvious. It's far from obvious that this was carried out, however. And then further down the page, at paragraph 670, you conclude that cross-disclosure between cases where Horizons had arisen was not being undertaken, and that there is, quote, no evidence of routine cross-disclosure where Horizon evidence was relied on. Is that right?
Yes.
Back in paragraph 19 of your report, no need to turn it up, you'd noted that you had seen discussions of the need to disclose issues in one case, in others where similar issues had arisen. Beyond the form of words that we discussed yesterday, was any such cross-disclosure in fact provided in any of the cases that you reviewed?
Not that I saw, no.
In your volume 2A report, if we can just turn that up, please, EXPG 605, at page 25, thank you. At paragraphs 71 and 72, you're dealing here with the case of Mr. Julian Wilson. You say, despite this issue having been raised before and at the time of Mr. Wilson's plea, that's looking at Horizon issues in other cases, being this. And at the time of Mr. Wilson's plea, there is no evidence of cross-disclosure of other cases where complaints about Horizon, even though the reviewing lawyers had personal knowledge of a number, at least by reference to the cases you've considered above. And then you say the relevance of such cross-case issues was highlighted in Mr. Wilson's case by a letter from his then MP, the Right Honourable Jackie Wilson MP, and in her letter to the Chief Executive Officer of the Post Office of December 2009, she referred to issues with the operation of Horizon that had arisen in the case of Mr. Wilson, and similar issues that had arisen in the cases of Hughie Thomas, Seema Misra, and also referring to the Falkirk Post Office. And you say it's pertinent to observe that if such cross-case issues were obvious to Mr. Wilson's MP, they should have been all the more obvious to those concerned in the cases who played a role in that of Mr. Wilson. And there is no evidence that cross-case disclosure was considered. And so are you there making the point that it was cross-disclosure was considered to be obvious to a layperson, in that case, Mr. Wilson's MP?
To someone who had knowledge of that, of the fact that such issues had arisen in more than one case, yes.
Overall, how serious a failure did you regard the absence of cross-disclosure in the Horizon cases that you looked at?
Well, the case of Mr. Wilson highlights it, in my view, but that in that case, counsel instructed for the Post Office to prosecute the case, both the person originally instructed when the case was charged and then the person who prosecuted it once it had reached court. Both raised the question of whether the kind of issues that Mr. Wilson was describing with Horizon had come up before, because it's clear that neither of them were aware that they had, but that they recognised if they had, that was potentially disclosable. And so the position appears therefore to be that those being instructed in these cases recognise that the fact that an issue with Horizon had come up before was potentially disclosable. And yet those who were responsible for the superintendence of disclosure in those cases, the in-house lawyers in the criminal law division, who knew that they had come up before because they were dealing with these cases again and again, had not identified that this was an issue even to be investigated for disclosure beyond the very limited discussions that I saw. And I consider that to be a serious issue because they should have been considering whether there was disclosure to be made in relation to the operation of Horizon anyway, but for them still not to be addressing it when they knew that these issues were coming up and had come up before is a serious concern.
Did you see any evidence of consideration of the issue and a reasoned decision to not give disclosure?
No. And so, for example, and I spotted an error in my report, for which I must apologise. In paragraph 667, I suggested that the same lawyer had dealt with the cases of David Blakey and Tahir Mahmood at the charge stage. I was wrong about that. It was Mr. Singh in the case of Mr. Blakey and Miss McFarlane in the case of Mahmood. But each of them then went on to deal in rapid succession with a series of further cases. For example, Mr. Singh dealt with the cases of Miss Palmer, Mrs. Rudkin and Mrs. Misra. Miss McFarlane dealt with the cases of Mr. Thomas and Miss Hall, each of which raised issues with Horizon in the same way that the cases of Blakey and McFarlane and Mahmood had raised issues. And yet I didn't see in their correspondence with the investigators anywhere them saying, it's interesting that this person is saying they'd had a problem with Horizon because we had this, didn't we, last time? And should we have a conversation about that? That would have been a step forward.
And that document can come down, thank you. Does the point that you made in 667 of your second report remain, that this was a small pool of lawyers?
Yes.
And what was the point that you were making on the back of it being a small pool of lawyers?
The fact that it was a small pool of lawyers meant that issues that were coming up in one case would resonate if they had come up before, because there was only a few of them dealing with those cases. And so they, in one sense, didn't need to be told by anyone that this was something that needed to be looked at, because they knew from their earlier experience in cases that it was an issue to be dealt with. To give a parallel, one of the virtues of the Treasury Council system is that because there is a small team who deal with these difficult cases, where one person has an issue in a case, someone else will have dealt with that issue before, and where there's an issue that does arise in one case, they can alert the others to watch out for it in other cases. This was a small team in much the same way, and the need for inevitability, perhaps, of sharing of experiences ought to have alerted them the fact that this was a problem that went beyond one case.
Thank you. Can we move to topic 9, which is the acceptance of pleas? And to start with, look at something that you say in relation to Mr. Singh, and it's a point that arises in a number of cases. And the point is whether the acceptance of a plea to false accounting is a concession or arguably a concession of the absence of sufficient evidence to theft. You address this on page 127 of your report. It's paragraphs 351 and 352. And at the end of 351, you say that Mr. Singh observed that if Mrs. Misra pleaded guilty to the false accounting charge, it's recommended that the prosecution in respect of theft is not proceeded with. And then 352, this was arguably a concession to the absence of actual evidence of theft and consistent with an approach whereby theft was charged to encourage pleas to false accounting. Now, I think on the last occasion, you confirmed that the judgment of the Court of Appeal in Eden made it clear that it could be appropriate to charge both theft and false accounting where they are either put as alternatives to each other or where they are both advanced to cover different forms or species of criminality.
Yes.
Would you agree that that means that the mere fact that theft and false accounting are charged in the same indictment is not of itself improper, so long as there's sufficient evidence and a public interest to charge both of the counts?
Yes.
And the two charges are either put as alternatives to each other or are referring to or addressing different species of criminality?
Yes.
You've also, I think, given evidence on the last occasion that evidential sufficiency and public interest must be kept under review throughout the life of a case.
Yes.
Does it follow from that that a change in circumstances may affect whether continuing a prosecution is in the public interest?
Very much so.
In a prosecution pursued by the CPS, for example, if a defendant was willing to plead guilty to one count but not another, would the CPS have to consider whether it remains in the public interest to go to trial on the outstanding count?
Yes.
And I think at least the 2010 edition of the Code dealing with pleas and the acceptance of pleas includes amongst the factors to be considered the following: whether the court will have sufficient sentencing powers to match the seriousness of the offending behaviour.
Yes.
And the wishes and interests of the victim.
Yes.
In a private prosecution where there isn't an obligation to prosecute, even if the evidential and public interest tests are satisfied, is a prosecutor entitled to consider whether, in the light of a plea or a proposed plea, pursuit of the remaining count or counts on the indictment is a proportionate use of the private prosecutor's resources?
Yes.
Given those things, why is it that you consider that Mr. Singh's observation must necessarily, in fact, I don't think you say necessarily, you say arguably, arguably amounts to a concession that there was insufficient evidence of theft?
Yes, and I don't say necessarily that does reflect Mr. Singh's position, but taking it as a starting point, Mr. Singh had reached a charging decision without setting out in any way the evidential basis for his conclusions, which means it is not clear to me where there was, on the face of it, no evidence of financial benefit to Mrs. Misra, that he had concluded that there was a realistic prospect of a conviction for theft of £74,609.84 when there was no evidence that Mrs. Misra had received £74,609.84. And so he had charged that and false accounting with no reference to the case of Eden, no reference to why both charges were there, how one was an alternative to the other, or how one reflected different criminality to the other, but had then said that he considered there was a realistic prospect of a conviction for theft, but if she pleaded guilty to false accounting, then that would be sufficient. And where there was no explanation as to how he had reached a conclusion as to theft, and where on the face of the investigation report there was a limit to the evidence that there had been theft, it struck me in those circumstances that it was arguable, rather than necessarily the case, that there was a recognition in his mind that the case for theft was not strong, and therefore false accounting was sufficient. And if that was his mindset, given the lack of evidence, I queried why he was charging theft in the first place.
Thank you very much. So it might be that even if there was sufficient evidence of theft and there was a public interest in prosecuting theft, it may not have been in the public interest or the post office's private interest to proceed to trial with the theft account if there was a plea to false accounting. But you saw no reasoning to that effect.
Yes.
On the face of the papers.
Yes, and I'll correct if I'm wrong, but I think Mrs. Misra did then plead to false accounting and was still prosecuted for theft. So,
Yes. That's exactly
and I
right.
saw no analysis to explain that either.
Thank you. Thank you. That can come down. Can we turn to considerations of confiscation? I think it's right that the 2010 iteration of the code did not state that the availability of the court's powers to make confiscation orders was a consideration that had to be taken into account as part of the public interest test. I think that came in a later edition of the code. That notwithstanding, would it have been a proper consideration for a prosecutor when considering whether to accept a guilty plea to some counts but not others, or to a lesser or a different offence, to consider the impact on the court's confiscation powers?
It would be reasonable to consider that, yes.
And so in Mrs. Misra's case, when the post office was, say, considering whether to accept a plea to false accounting or whether to proceed with the theft count, would the impact on confiscation have been a legitimate factor for the post office to consider as part of the balancing exercise?
In the sense that if the theft count reflected the actual benefit to Mrs. Misra of the money and an appropriation by her of the money, which could lead then to confiscation if she were convicted of taking the money through a conviction for theft, on the one hand, and false accounting reflecting putting off the evil day, to use the words in Eden, to avoid identification that there were errors that had not involved her taking money, on the other, through false accounting, the latter route arguably not leading to confiscation.
Was there any evidence that that was the kind of reasoning that we've just explored ever brought into account in Mrs. Misra's case?
No.
Can we look more generally about the issue of accepting pleas to false accounting instead of theft? And you address this on page 227 of your report. If that can be shown, please. 227 at paragraph 640. In 640, you say the approach to charging as between theft on the one hand and false accounting on the other lacked consistency, and that in a number of cases there was also a lack of consistency in the charging decision. exhibited by the willingness to accept a plea to false accounting instead of theft. Are those comments limited to the particular facts of one or more of the cases that you examined, or are they a general point?
I think more of a general point.
Can you help us then? Why would a willingness to accept a plea to false accounting necessarily imply a lack of confidence in the evidential merits of the theft charge?
Again, it doesn't necessarily reflect one, but where in case after case after case, a charge of theft was selected without any explanation as to the evidential basis for it, particularly in relation to an evidential basis for appropriation and or dishonesty. And then there was a willingness to accept a plea to false accounting, which carried with it a recognition that there was not sufficient evidence of those elements of theft. It did raise the question as to whether theft was being charged without sufficient consideration of those elements. And also, because the charging decisions were such models of brevity, it was very difficult to see how the thought process had been gone through as to why theft was there as well as false accounting in these cases.
Thank you. Can we turn to page 229, please? And paragraph 644. You say, however, the greater concern in a number of cases that I have considered was that evidence that the theft charge was used as a means to pressure a defendant into pleading guilty to false accounting with conditions attached to the acceptance of that plea. And I think you give three examples. Huey Thomas, between paragraph 645 and 647. Josephine Hamilton, 648. And then Alison Hall, 649 to 651.
Yes.
Three examples.
Yes, and one, if one wanted a fourth, Mrs. Henderson would
Alison Henderson,
same
too.
category.
Thank you. If we can just look at those, the three that you've given
Yes.
in the report, starting with Huey Thomas, Noel Thomas. If we look at what you say at paragraph 645 onwards, he pleaded guilty to false accounting in September 2006, theft charge not pursued. The memorandum of the hearing noted, quote, this was pursuant to a basis of plea which makes it clear that no blame was attributed to the Horizon system. The defendant accepted there was a shortage, but he couldn't explain how it came about. He accepted that as a sub-postmaster, he's contractually obliged to make good the shortage. And you say, in other words, the acceptance of this plea was made conditional on the repayment of monies which, consistent with the plea, had not been shown to have been taken, and to an undertaking not to criticise the Horizon system. This appears from the material you'd seen to have followed from a discussion between the principal post office lawyer, Julia McFarland, and the post office agents in the prosecution, in which Julia McFarland said, quote, we would proceed with false accounting providing the defendant accepts that the Horizon system was working perfectly. Further instructions are that the money should be repaid. You say that Mr. Thomas reported to the second site review that the approach taken was aggressive and inappropriate. You say that from the perspective of a defendant, it shouldn't be forgotten, there's a significant, very significant difference between theft and false accounting as to outcome. Theft by an employee in breach of trust in the period with which the inquiry is concerned was recognised, and you cite two cases, Barrack and Clark, from the 1980s, establishing that as an offence usually attracting an immediate custodial sentence, even in a case with strong personal mitigation. A defendant confronted by the evidence of loss deriving from the Horizon system and a lack of possible questions as to its reliability would understand that a plea to an alternative offence would increase the chances of retaining their liberty and it's reasonable to anticipate they would receive legal advice to that effect. Does that include, for example, an anticipation or at least a hope of a suspended sentence?
Yes.
At 647, the Post Office submitted in the context of the second sight review that the decision to accept the plea was reached in accordance with the code. However, as was acknowledged, there's no evidence of such a review, which in the first instance did not follow the code test. Rather than a review of the evidence, the prospects of conviction or the public interest, the only matters raised in the material that you'd seen are the recovery of money and the protection of the reputation of the Horizon system. On a scale of concern about the conduct of prosecutions, where does what you identified there sit?
I recognise that it is always open to the prosecution to consider whether, on a review of the evidence and a review of the public interest, in fact a plea to an alternative count meets the justice of the case. I also recognise that it is always open to the prosecution to consider a proffered basis of plea and identify whether that basis of plea is acceptable, and if it is not acceptable, to make that clear to those acting on the behalf of a defendant. What concerned me here was that the discussions that I saw in the communication involving Mrs. McFarlane were investigating internally their view as to whether a plea to false accounting would be acceptable in a case where she had identified at the charging stage there was a medium prospect of success. And identifying in that context the concerns being recovery of the money and no criticism of Horizon. And it's putting those factors together, it seemed to me a reasonable reading of what occurred was that those involved from the Post Office side were identifying their conditions for a plea being accepted, which were conditions of the recovery of money where there was no acceptance by the plea that money had been taken, and lack of any criticism of the system, which was something that Mr. Thomas had identified from interview on as being a concern on his part and would have been mitigation for him. And so that's a very long way of answering your question, that I think there's a very real concern that on the face of those facts, this was a plea that was being tailored to address concerns that the Post Office had in terms of getting the money and protecting the reputation of their computer system, rather than an assessment of the factors in the code by reference to evidential sufficiency or the public interest.
Thank you. And cutting it shortly, do the same issues arise in paragraph 648 concerning the case of Josephine Hamilton and 649 and following in the case of Alison Hall?
Yes.
Thank you.
And I should just add in relation to that, those cases, those of Mrs. Hamilton and Mrs. Hall, were considered by the Court of Appeal, and the Court of Appeal took a very clear view of what they considered had occurred there, and the material that I saw did not in any way lead me to take a different view from Lord Justice Holroyd and others.
That's paragraph 650 of your report you're referring to there. If we
Yes.
turn to that on page 231. And if we scroll down, thank you. You say adopting the language, that's you adopting the language of the Court of Appeal.
Yes.
When it considered the cases, it was improper for the Post Office to have made their acceptance of a plea to a lesser alternative offence conditional on a defendant not making any explicit criticism of Horizon. You say that it was improper of the Post Office, but who within the Post Office had engaged in that improper conduct?
Well, in each of those cases, there were documents that I saw that involved discussions between those in-house, so the lawyers and investigators, about effectively, again, the preconditions or the necessary conditions for there to be a plea accepted by reference to money and by reference to the reputation of Horizon.
Thank you. So it's the lawyers on each occasion?
Those are the persons whose emails I saw or memos I saw that identified those being the factors.
Thank you. And then the last sentence of that paragraph, I think this is something that you've mentioned a moment ago. It would have been a relevant and likely strong mitigating factor that the falsification of records was to cover a shortfall for which the defendant was not responsible and may instead have been a computer error to deny the defendant that mitigation was wrong. Can you just explain what you mean there, please?
Well, it's on the one hand, someone who has dishonestly and deliberately manipulated the system, and on the other hand, someone who has been confronted by an error in the system that they cannot understand, but which they do understand they will be held accountable for and made to pay for, and in panic has adjusted the system to stave off the day when they know that will be found out. On the other, it is a significant potential difference as to how a judge will view their offending. If they are, if it is a one-off result of panic through something beyond their control, a judge is much more likely to view that sympathetically and much more likely to consider that a custodial sentence is not required. And if they are prevented from advancing that mitigation, then they are being prevented from putting forward a strong argument for them not going to prison.
Thank you. And then lastly, over the page, paragraph 651. The Court of Appeal in Hamilton, it's there, paragraphs 113 and 147, said that it was irrational and unjust for the Post Office to have required the defendant to accept that they had the money short of theft. And the Court of Appeal observed that the Post Office's conduct gives a firm impression that the condition of repayment in return for the Post Office dropping the charge of theft placed undue pressure on Mrs. Hamilton. It gives the impression that the Post Office was using the prosecution to enforce repayment. Did you find any material that undermined the impression that the Court of Appeal formed?
No. The words that her plea would be accepted on her recognition that she had the money short of theft were words from the lawyer in the criminal law department at the Post Office. And again, and that was a discussion in advance of Mrs. Hamilton pleading to false accounting. And so on the one hand, you have an acceptance of a plea to adjusting records that revealed a loss rather than causing the loss in the sense of taking the money through the acceptance of false accounting rather than theft. And yet, it being a condition of that the individual in the criminal proceedings be made liable for paying back money that you are accepting they have not taken. That there may be a separate civil discussion as to whether under the postmaster's contract they were required to make good a loss that they had not caused, but this is in the criminal proceedings, making it a condition or pursuing criminal mechanisms in order to get money that you are accepting they have not taken.
Thank you. Can we turn to topic 10? That can come down, thank you. And the last topic is expert evidence. Can we start by way of a recap of your previous evidence to the inquiry? You said that a prosecutor intending to rely on expert evidence in criminal proceedings was, during the relevant period, subject to the following obligations, and this is just by way of brief recap to the questions I'm going to ask, to satisfy themselves that the expert had been appropriately instructed, including by the provision of a detailed letter of instruction or email or terms of reference, to provide the expert with instructions upon what it is that his or her opinion is sought, setting out the issues or questions that the expert is expected to address or to answer, to provide explicit guidance as to what it is the expert is being asked to do and the material they're being asked to consider in order to do it, to set out the material upon which reliance has been placed in the prosecution and which may be relevant to the questions that the expert is expected to answer, to inform the expert of their duties under the common law and the criminal procedure rules, to make sure that the expert not only understands their duties, but that they had complied with the duties in order to ensure that the expert's evidence was admissible. And lastly, to satisfy themselves that any material or any literature of which the prosecutor was aware and which might undermine the expert's opinion was reviewed by the prosecution and disclosed to both the expert and to the defence.
Yes. And the duties on the expert were well established before the inquiry's period started. The responsibility of the person instructing an expert, the lawyers instructing an expert to communicate those duties to the expert to make sure the expert understood them, evolved over the period of the inquiry, but from quite early in the period it was again clear that that was what was required of them.
Yes. In the 5 case studies in which the Post Office obtained evidence from Mr. Gareth Jenkins, that's Thomas, Misra, Allen, Sefton and Neild, and Ishak,
yes,
forgive the use of the surnames, did you identify any document or evidence that demonstrates that Post Office prosecutors or later those acting on their behalf from Cartwright King informed or instructed Mr. Jenkins about the duties of an expert?
No.
Did you see any evidence that such prosecutors were themselves cognizant of the existence of any of these duties?
No.
And did you see any evidence that they complied with any of these obligations in their dealings with Mr. Jenkins?
No.
Did you see any instructions to Mr. Jenkins which might conform in any way with a written form of instruction that a prosecutor ought to provide to a person whom it is proposed to give expert witness evidence? In relation to the evidence that Mr. Jenkins himself gave, you told us previously about a case in 2006 and then the criminal procedure rules, Rule 33, which came into force in November 2006, that there were a number of necessary inclusions in a report.
Yes.
We've looked just now at duties on a prosecutor. We're now turning to duties on an expert themselves. Did they include, I'm going to summarise them all,
Thank you.
Details of the expert's academic and professional qualifications, experience and accreditation insofar as they're relevant to the opinions expressed?
Yes.
A statement setting out the substance of all of the instructions received, the questions upon which an opinion is sought, the materials that have been provided and considered, assumptions which are material to the opinions expressed, information relating to who carried out any examinations or the methodology used, and if they weren't carried out by the expert themselves, the extent to which there was supervision, whether there was a range of opinion in the matters dealt with in the report, a summary of that range of opinion, and the reasons for the opinion given, relevant extracts of any literature or other material that might assist the court, and then finally a statement from the expert that they had understood and complied with their duty to the court to provide independent assistance by way of an objective and unbiased opinion.
Yes.
Were they the necessary inclusions in the report itself?
Yes.
In the 5 case studies that you have considered, did you find that the witness statement served by Mr. Jenkins set out any of those matters that I've mentioned that are necessary inclusions for an expert report or an expert statement?
In most of his statements, he did set out his qualifications. In some instances, or at least in one instance, those who were receiving the statement from him, the lawyers at the post office, did ask him to do that. To an extent, he set out the questions that he'd been asked, in that he would identify what he was making the statement about, but he would not set out the details of what had been asked of him. He did not, I think, usually set out what materials he had been provided with or what sources of information he was relying upon. Insofar as that was the work of others beyond himself, that was not identified by him. Insofar as there was a range of opinions and or contrary views or material that was capable of undermining his opinions, that was not set out at all. In terms of literature, which would include expert reports that he had seen in earlier cases in relation to Horizon, and which would include his own expert reports in earlier proceedings, those were not normally set out, and there was never a statement identifying that he recognised the duties that were imposed upon him.
Thank you. Did you see any evidence that the Post Office informed Mr. Jenkins that the printed statements should contain those necessary matters?
No.
Did you see any evidence that the Post Office and later lawyers at Cartwright King were aware that an expert report or an expert statement should contain those necessary inclusions?
I never saw any material that I can think of that involved any discussion of that to tell me whether they appreciated that or not. They certainly didn't say they did.
When you gave evidence on the last occasion, you told us that even with those experts who were trained, accustomed, and made their living, or at least in part made their living, from giving expert evidence, i.e. even if you were preaching to the choir, a prosecutor had to make sure that the expert understood what their duties and obligations were. Is that right?
Yes.
And you emphasised that in relation to an expert who was not functionally independent of the prosecutor, that it was all the more important that they understood the nature of the role that an expert performs and that they properly understood what the requirement of independence actually entailed.
Yes, and not least because the expert would need to demonstrate that independence, and so they needed to be reminded to set out the basis upon which it was so demonstrated.
Was Mr. Jenkins one of those witnesses in respect of whom there was that heightened duty to ensure that they understood the nature of their expert duties and in particular what the requirement of independence entailed?
Yes.
Was that because he was not a professional expert witness?
It was, yes, it was because he was giving evidence of something out with the knowledge of the jury, because it was something about which he had knowledge, because he worked for the people whose software it was.
So his day-to-day work was as a software engineer or a computer engineer rather than a professional witness?
Yes.
He wasn't, I think, a member of any expert witness institute or similar?
I don't recall him listing any such membership.
And would you agree that the heightened duty applied in particular because he was not independent of the subject matter of his evidence? He was in part speaking about his own work.
Yes. His own work and the work of his employer.
And he wasn't, would you agree, functionally independent of the prosecutor?
No, because of the interrelation between the product that he was talking about and the application of that product by the prosecutor.
Have you seen anything in the material to suggest that the Post Office or later Cartwright King lawyers understood the heightened need to ensure that Mr. Jenkins understood his duties as an expert, in particular the especial need for independence and demonstrating independence.
They understood the how it might look, in the sense that in the conversations that we looked at in emails leading up to the generic statement in 2012, there was discussion about whether it might be better to have someone independent of Fujitsu rather than working for Fujitsu delivering that statement. That was as far as it went.
So recognising the lack of independence, but then not taking the next step, what do we do to address it?
Yes.
Before we look at any of the communications lawyers had with Mr. Jenkins, did you observe that some of them, and this is communications between lawyers and investigators on the one hand and Mr. Jenkins on the other, were inconsistent with how a prosecutor ought to address and to communicate with an expert?
Yes, and I should say that I have seen a lot more in terms of communications between those at the post office on the one hand and Ms. Jenkins on the other within the last week than I had before. That which I had seen before was a cause for concern. That which I have seen since heightened those concerns considerably.
Can I summarise them? Did you find that there was a lack of formality in the communications?
Yes.
Did you find the guidance given to him to be adequate or inadequate?
Inadequate.
Did you find some of the language used to be appropriate or inappropriate?
Inappropriate.
And did you find that whether any of the instructions given had as their intent the service of the post office's interests rather than the provision of an independent opinion?
Yes.
As well as some of the communications being inconsistent with the way a prosecutor ought to approach an expert, did you find any of them to be the opposite of that, i.e. the antithesis to it?
Yes.
If it's right that the post office or its agents, Cartwright King later, did not provide Mr. Jenkins with written instructions that conform to the requirements that we've mentioned, didn't provide Mr. Jenkins with instructions as to his duties as an expert, and none of the statements included the necessary elements that we've identified, would you be able to draw an overall conclusion that there was a fundamental failure by the post office properly to instruct Mr. Jenkins as an expert?
Clearly, that's ultimately a conclusion for others than me, but certainly it is not a conclusion from which I would dissent at all.
And with the limitation you've just included, was that a persistent failure?
Yes.
You told us back in your first report, it was paragraph 67, no need to turn it up, that there was, quote, no prosecution document that I have seen that gave guidance as to what an expert being instructed needed to address.
No post office document? No.
Yes, no post office document.
Yes.
Was that absence of a framework within prosecution policy reflected in the post office's practice as you saw it in the case of Mr. Jenkins?
Yes.
The things we've spoken about so far were failures of omission, things that the post office didn't do or its lawyers did not do. Did you identify any material in the 5 case studies that prosecutors and investigators communicated with Mr. Jenkins that were inconsistent with the approach that a prosecutor ought to take? So worse than mere failure.
But some of the emails that we considered yesterday, where on the face of them, they were telling the expert what to say and telling him what not to say. That, I think, goes beyond an omission. In material that I've seen, again, since the end of last week, there are examples of Mr. Jenkins' statements being rewritten by investigators and lawyers at the post office, in the sense of them saying, can you take that bit out, please? Or that bit doesn't sound good, can you say something else? And this is in relation to the evidence of an independent expert. That is the role that Mr. Jenkins was being advanced to perform. And whilst it is entirely right and proper for an investigator or prosecutor dealing with an expert to say, I don't understand that paragraph, can you elucidate it? Or can you think about this section in the light of this or that you haven't seen, or this or that you say further down? That is different from saying that bit is going to give rise to disclosure issues, or that bit is going to cause us problems, can you take it out? Or just deleting it in the way that they did from his draft.
Sometimes they wrote, can you do X, can you delete, can you add, can you rephrase? And sometimes they simply cut it out.
Yes.
And the issues that you identified where the evidence was amended, deleted or tailored in that way, did they go to horizon integrity issues?
Absolutely.
How serious, in your view, was this conduct?
Extremely.
Did any of the issues that we've identified so far go to the admissibility of Mr. Jenkins' evidence?
They by, for example, removing aspects of his statements which were parts that qualified his opinion or identified contrary views to his opinion, they resulted in the final versions of the statements no longer complying with the requirements for an admissible expert statement. And they also, in various respects, removed the independence of its content. And so, yes, they clearly affected its admissibility. Had any of that been appreciated by anyone who had the opportunity to question its admissibility?
And in order to put that person in a position to do so, disclosure of the communications would have been necessary?
Yes.
Did you see any evidence at all that such communications between investigator and lawyer on the one hand and Mr. Jenkins on the other were disclosed in any of the 5 cases?
No.
Did you see any evidence of any formal request from the post office to Fujitsu for third-party disclosure about the matters that Mr. Jenkins was referring to? So to take an example, the locking issue, which caused transactions to be lost, or the record of system errors, the known error log. Did you see any communications at that level?
No.
And did you see anything to suggest that the post office pursued such issues with the Fujitsu head of legal, despite, on occasions, that channel of communication being used?
I can't think of any, no.
Thank you. Can I turn then, that's the 10 topics, over to the case studies? Your reports address 22 case studies, and your evidence speaks for itself. It's been disclosed to all call participants and is available on the inquiry's website. I'm not going to go through each of the 22 case studies, and instead only cover those where one of the call participants has asked me to ask questions of you by way of challenge to what you say, or where one of the call participants has asked for additional context to be given to what you do say in either of your reports. Can I start then with Lisa Brennan? This is paragraph 46 of your volume 2 report, which is on page 24. there's no need to turn it up for the moment. In general terms, you there are critical of the failure to conduct a fuller financial investigation as to any financial benefit to Miss Brennan of the conduct that was alleged against her. Yes?
Yeah.
As you said yesterday, investigating a suspect's financial records was a reasonable line of inquiry.
Yes.
During the period 2000 to 2013, would ordinary theft and fraud cases be prosecuted in the public sector, e.g. by the police and the CPS, without any inquiry of this sort having taken place?
I'm sure there will have been some, but certainly my experience is that follow the money is a mantra. Those dealing with any form of financial crime, and so they would normally look. Because if they found evidence of the money, for example, going into someone's bank account, that would be quite good evidence.
Yes, so you'd want to do it as a prosecutor trying to prove your case.
Absolutely.
But you ought to do it, I think you told us yesterday, as a reasonable line of inquiry because it might assist the defendant too.
Yes.
Because an active and healthy financial investigation which produced nil returns, it might be powerful evidence for a defendant to be able to deploy.
Yes, especially if they have, in interview, said in terms, I didn't take the money. That raises the reasonable line of inquiry of, well, did they? And the obvious place to look is to see whether they've got it. And whether that be a new speedboat or money in the bank, you have a look.
Was it usual in that period, 2000 to 2013, for charging decisions to be made in cases prosecuted by the CPS whilst financial inquiries were outstanding, if it was nonetheless the case that there was sufficient evidence to provide a realistic prospect of conviction?
That would be a fact-specific assessment in terms of where the financial inquiry was and what material had thus far been generated by it. But clearly, if there was, if a prosecutor was satisfied, despite the fact that the financial inquiry was ongoing, that there was a realistic prospect of conviction, then they would be entitled to reach an assessment, providing they were also satisfied that what was outstanding didn't have a bearing on the public interest assessment.
I think you would agree that it's, in a charge of theft, it's sufficient to prove the fact of the theft, whether by direct evidence or circumstantial evidence, without also, in fact, being able to show where the money went.
Yes.
Was your experience in looking at these papers that such financial inquiries that were made had as their focus not proving or disproving theft, but recovery of proceeds for the benefit of the post office?
Yes, in some cases it wasn't very clear what they had made the financial inquiries that they did make for, but because there would be a reference in an investigation report to the fact that they'd asked the postmaster for consent to access their bank account. They'd obtained that consent. They may have obtained some bank statements, and then there'd be no further reference to them. And so it wasn't quite clear what they'd done with them. But where there was more intensive examination of the finances, it did appear to be by financial investigators preparing for confiscation rather than investigators preparing for prosecution.
Would you agree that in the context of a fraud involving the alleged theft of cash of the type alleged in Lisa Brennan's case, that the absence of evidence of her having the missing money could not exclude the possibility that she did in fact take the cash?
It couldn't exclude it, no.
Given that the case was left to the jury on the basis that there was no evidence of her having the money, how, in your view, could an investigation of her finances by the post office have placed her in a more advantageous position than she was either at the point of the charging decision or before the jury?
Only that if it could have confirmed that they had looked and not found any evidence that she had benefited financially, and or confirmed that she, if this were the case, had attempted to make repayments at an earlier stage of losses, and or if it confirmed that she was not in a position where she needed to steal the money, those things would have further supported her case, not least because they were coming from the prosecution rather than, for example, just from her.
Thank you. That's all I ask in relation to Lisa Brennan's case. I'm going to move over the cases of David Yates, David Blakey and Tahir Mahmood and turn to the case of Carl Page, and in particular your consideration of his case at page 58, paragraph 146 to 148 of your report. Page 58, please. And paragraph 146, and between paragraphs 146 and 148, you raise some criticisms based on your understanding, I think from the Court of Appeal Criminal Division's judgment in Hamilton, that the prosecution had changed its case between the first and the second trial.
Yes.
The inquiry has heard some evidence since the Court of Appeal's decision from Warwick Tatford, the prosecution junior to Mr. Stephen John at the first trial and sole prosecuting counsel at the second trial. He's told the inquiry that there were 2 counts in trial 1. The first count was an alleged conspiracy to defraud between Mr. Page and Mr. Whitehouse in relation to foreign currency, involving the use of a Ford, F-O-R-D-E, money changer,
yes,
and not Horizon, and a second count of theft of £282,000 alleged against Mr. Page alone, based on an audit shortfall, and therefore based on Horizon. Both defendants were acquitted on count 1 at the first trial, jury unable to reach a verdict on count 1 at the first trial. Therefore, there was a retrial on count 2 alone,
yes,
against Mr. Page. And that as such, the second trial was a retrial and did not involve a change of case. Was your conclusion that there had been a change of case based on what the Court of Appeal Criminal Division had said in Hamilton?
In part. Also based on the assessment in the second sight review, which was to the same effect.
That's paragraph 147 that you're referring
yes,
to there. Other than those tertiary sources or secondary sources, did you see anything in the contemporaneous papers to suggest that there had been a material change of case between the 2 trials?
I saw a transcript of the evidence, or more particularly cross-examination of Mr. Page at the first trial, which was very much to the effect that he had stolen foreign currency, and that was the basis upon which the theft charge appeared to be presented there, which was how Second Sight characterised it in their review. So there was that material, that contemporaneous material, that accorded with what they were saying had been the prosecution's case at the first trial, which was not its case at the second trial. I can't, on the top of my head, remember anything else, but I didn't see anything equally that would positively say that the case had not changed in the sense of a review between trial 1 and trial 2 as to how the case would now be put in the light of the acquittal on count 1 first time round.
Does anything that I have said in relation to what Mr. Tatford has told the chair change your view in relation to this aspect of the case against Carl Page?
Clearly, I haven't considered what Mr. Tatford had to say. All I can say is that the material that I saw, and I can only speak to that, didn't cause me to take a different view to either Second Sight or, more pertinently, the Court of Appeal as to the fact that there had been a change of case.
Thank you. Can I turn to Oyeteju Adedeyo's case, please? You pick this up, page 66 of your report, paragraph 169 and following. And I think amongst the material that you've seen since the preparation of your original report and this revised report included the CCRC referral document.
Yes.
The reference to which we needn't display it is POL 0012-1224. Did your view remain that the case was poorly investigated?
Yes.
Did your view remain that, in particular, Mrs. Adedeyo's account was not explored or examined by the investigators or the prosecutors?
Yes, and in that regard, I focus on the account that she gave at the time. I've seen what she has said about that since, but I focus purely on what she gave as an explanation to the investigators at the time, which was an account that required investigating.
Was it incumbent upon the investigator, Miss Bernard, to investigate that account to see, for example, whether there had been any payments to third parties by Miss Adedeyo?
Yes.
And would that have been a relatively straightforward exercise?
I would have thought so. I'm not a financial investigator, but yes, I'd have thought so.
Did you read the transcript of the interview of Mrs. Adedeyo?
Yes.
I wonder whether we can do this without turning it up. Would you agree or disagree with the suggestion that when asked open questions, Mrs. Adedeyo appeared incoherent in some of her answers?
They weren't easy to follow.
Did you find that the account that was ultimately attributed to her in the investigating officer's report was one that had been extracted through closed questions to her?
Yes, I think that's a fair characterisation. There was when open questions were asked, initially the account she gave was not clear, and more closed questions were then asked, from which a clearer account was derived. But clearly it was a clearer account based on what she was agreeing with.
Would you agree or disagree with the suggestion that the account overall was internally inconsistent and confusing?
I can certainly understand why that would be suggested, yes.
When she gave evidence to us, the investigator, Natasha Bernard, said that she viewed it as inconsistent and confusing. And she said that it's quite clear from her report that she didn't believe what Mrs. Adedeyo was telling her.
In certain respects, yes, I agree with that.
Given that the equivocal nature of what was being said, would you agree that that added an impetus for the case to be properly investigated?
Yes.
There wasn't any clear evidence of a theft and a contradictory or internally inconsistent, in some respects baffling confession.
Yes.
Would that have been a questionable basis to prosecute?
Without that being resolved, yes.
If we look at paragraph 181 of your report, please, which is on page 70. Last sentence, in the light of what you said earlier in paragraph 181, in Mrs. Adedeyo's case, Horizon reliability was not an issue, and non-disclosure relating to the operation of Horizon potentially less of an issue as a result. Are you there essentially adopting the same approach as the Court of Appeal Criminal Division?
Yes, I hope so.
Thank you very much. Can we turn to Mr. Thomas's case next, please?
Before you do, Mr. Beer, Can I just understand what went on in Mrs. Adedayo's case? Her conviction was quashed by the Southwark Crown Court. That's correct, isn't it?
Yes.
So this is purely technical, but where you write that she pleaded guilty at the Crown Court, I don't think can be right, can it? Presumably what happened, she pleaded guilty at the Magistrates' Court, but was then committed for sentence.
That must be right, yes, sir.
That's right. That's just a mere technicality. But what's of more interest in her case is that there's no real rationale, is there, in how her conviction was quashed or why it was quashed, because we haven't got a formal judgment of the Southwark Crown Court. Is that correct?
We have a transcript of the hearing at which it was indicated by counsel acting for the Post Office that although they didn't accept the reasons that had been advanced on Mrs. Adedayo's behalf for why her convictions should be quashed, they nevertheless considered that it would be contrary to the public interest to seek to uphold her conviction, and so they didn't oppose her appeal. There was no judgment given, and I'll be corrected if I'm wrong about this, no judgment was given by the Recorder of Westminster who presided over that hearing separate from that. The transcript is less than helpful as to exactly why it came about that Mrs. Adedayo's conviction was quashed. Certainly, the Post Office made clear they didn't accept a good deal of what Mrs. Adedayo's case, as considered by the Criminal Cases Review Commission, had been.
But so in effect, at court, there was an issue which was unresolved by the judge. Mrs. Adedayo's case was presented in a particular way. The Post Office said what you just described to me, and the judge didn't determine the issue between them.
No, that's right, sir.
So am I right in thinking that the only objective, by which I mean independent of Mrs. Adedayo or the Post Office, assessment is that which we currently have, is that which is contained in the reference by the Criminal Review Commission?
Yes.
Yeah, fine. Thank you. Sorry, Mr. Beer, I wanted to be clear in my mind about this case.
Yes, thank you. I think the document that you saw was a transcript of the hearing at Southwark Crown Court in front of Her Honour Judge Taylor.
Yes.
Of the 14th of May 2021. And that ends, the hearing starts at 10:47. Do you want to just have a look at it? I'm not sure it's going to be able to display this. So I think it's volume 1 of the Rule 10 material at tab D32.
Thank you very much. Yes, thank you.
Is that the relevant transcript?
It is, yes.
The hearing starts, we can see on page 2, at 10:47. And Miss Carey, I think that's Jacqueline Carey, appears on behalf of the prosecution and speaks over pages 2, 3, and 4. And then Mr. Maloney, who appeared for both appellants,
Yes.
Says a few words, 10 words or so.
Yes, he was largely inaudible, apparently.
Yes, which is no doubt due to the recording rather than Mr. Maloney.
Sure.
There's then a discussion, or something that Her Honour Judge Taylor said, which concerns jurisdiction.
Yes, because Mrs. Adedayo had pleaded guilty in the, and so you're entirely right, she pleaded guilty in the Medway Magistrates' Court to the offences and was then sent to the Crown Court, to Maidstone Crown Court for sentence. And so procedurally, her guilty pleas had to be set aside before her conviction could be quashed. And so that's the discussion at the end.
And then the hearing concludes with this, Judge Taylor saying, "Thank you. In these appeals of Mr. Karia and Miss Adedeo, the court finds that the effects of Section 1124 of the Criminal Appeal Act 1985 are such that they do not have to apply to set aside their guilty pleas. We adopt the background inaudible to these cases, which is set out in Hamilton against the Post Office, and the citation is given. Whilst it is not conceded that by the Post Office that these are inaudible cases, in terms of judgment, the appeals are not opposed, inaudible, will not be contested, and in the public interest, inaudible. Their sentences have been served, and we hope that, inaudible, they can put this behind them and continue with their lives without the shadow of a conviction." Any other applications? It says Mr. Carey.
Yes.
It should be Miss Carey.
Yes.
And she says no, thank you. Is that the extent of a judgment determining the appeal?
Yes, it is.
So I hope that helps. Thank you.
Thank you. Yeah.
Can we turn on to Mr. Thomas's case then, please? This is paragraph 198 and following of your report on page 76. In fact, we needn't turn this up. I can deal with this without looking at this material. In paragraphs 193, 198 and 213 of your report, in the context of Mr. Thomas's case, you examine the preparation of a witness statement by Gareth Jenkins.
Yes, I think the first witness statement he made.
Exactly. You say at paragraph 198 that consideration of the reference material, i.e. material that was referenced in the Gareth Jenkins chronology, is necessary. We mentioned the nature and status of that document yesterday.
Yes, that's right.
So can we look at the reference material and indeed some other material, underlying material, in chronological order? Can we start, please, with FUJ 0012 2203? And can we look at page 6, please? And if we scroll down, please, we should see an email we can from, if we just scroll up a little bit, thank you, from Graham Ward to, and it's a generic email account, to Fujitsu of the 10th of March 2006. This appears to be the original or originating form of instruction from Mr. Ward of the Post Office to Fujitsu. And if we just scroll down, please, and go on to page 7. He says, on a separate matter, I also require a witness statement in respect of the following ARQs, all of which relate to the Garwin SPSO. That's Mr. Thomas's branch on
Yes, that's right.
Anglesey. We need the usual leave out paragraphs H, B, and J, but we do need paragraph K, call logs, covering an analysis over the period 11th of January 04 to the 30th of November 05. And then Penny, you may recall this one, which relates to nil transactions. Can you add an extra paragraph in your statement explaining how online banking transactions are processed and the data downloaded and how nil transactions can occur. If we go forward, so that's the 10th of May, Post Office, Ward to Fujitsu.
Yes.
If we go forwards, please, to the 21st of March, FUJ 0015 2582. And look at page 2, please. If we scroll down. Thank you. We should see an email from Mr. Pinder to Mr. Jenkins with a heading, Fujitsu statements at Garwin. As discussed, please see extract from a recent email below in italics from Graham Ward. We've just looked at that email.
Yes.
Regarding provision of a statement about nil transactions and online banking. If they're able to put something together for us, I'd be very grateful. If you send it back, I'll arrange for Naina or Penny to write into a statement for your signature. And then you'll see the relevant part of Mr. Ward's email cut in to this email and the part in italics. Can you add an extra paragraph in your statement explaining how online banking transactions are processed and the data downloaded and how nil transactions can occur? Having looked at this material, do you agree that it was the Post Office via Mr. Ward, routed through Mr. Pinder, who had asked Mr. Jenkins to focus on the issue of nil transactions in the witness statement?
Yes.
Rather than a request to consider any broader issue affecting the operation and reliability of Horizon?
Yes.
Would you agree, you'll see the reference to the 3 ARQs in the first line of the cut-in email. I'm not going to read the numbers out. That it was the Post Office which had selected the 3 specific time periods for the examination of nil transactions, and that it had done so by enclosing ARQs for time periods that it had selected.
Yes.
Would you agree that the this instruction to Mr. Jenkins didn't constitute or indeed come close to being a proper instruction to an expert?
Yes.
Instead, it's a request coming from the Post Office to the Fujitsu litigation support team, asking them to add a paragraph to their standard statement, which was then rerouted to Mr. Jenkins.
That was how I read it, yes.
Quite aside from the format of the instruction, is it right that you saw no material in which the Post Office provided to Mr. Jenkins detail as to what the prosecution case was against Mr. Thomas?
That's right.
No material setting out what Mr. Thomas had said, for example, in interview.
Correct.
Or in the audit and in the audit report.
Yes.
And there was no analysis for him of the competing issues between the parties.
No, that's right.
Would you agree that on these materials that Mr. Jenkins wasn't in fact instructed to undertake an examination of the scheme?
Yes, I agree.
Of the system?
Yes.
Thank you very much. So it's just gone past 11 now. I wonder whether we could break until 11:45.
Yes, certainly. Yeah.
Thank you. So good morning. Can you continue to see and hear us?
Yes, thank you.
Before I continue with the chronology in Mr. Thomas's case, can we just return to Miss Adedeo's case? and just clarify a couple of points in the light of the questions you asked and the evidence that Mr. Atkinson gave. Can we start, please, Mr. Atkinson, just by explaining the different nature of appeals from the Crown Court to the Court of Appeal Criminal Division and from a Magistrates Court to a Crown Court in CCRC reference cases? Is it right that an appeal from the Crown Court to the CCAD it is essentially a review of the safety of the conviction?
Yes.
Whereas if a person has pleaded guilty in the Magistrates Court, there is no power to appeal unless the CCRC make a reference.
Yes.
If the CCRC make a reference, the test that the CCRC apply is not whether the conviction is unsafe, but whether it's arguable that it might be.
Yes.
If the CCRC do make a reference to the Crown Court on a case involving a plea in the Magistrates Court, that results in a hearing de novo.
Yes, and so a rehearing of the case.
Yes, so essentially a retrial.
Yes.
A rehearing of the case.
Yes.
And upon such rehearing of the case, the prosecutor must or ought to consider both limbs of the code test at that point in time.
Yes.
What happened in Miss Adedayo's case was that the Post Office made a concession on the public interest limb of the test, as explained by Miss Carey in the transcript, that limb was not at that point satisfied.
That's right.
That approach by the Post Office meant that Mrs. Adedayo did not have the opportunity to argue by reference to the evidence and to make submissions whether the evidential threshold was met. That wouldn't be for the court anyway, but to argue in court by reference to evidence as to whether her case was an Horizon case or not.
No, that's right.
Is that why we don't see a judgment from Her Honour Judge Taylor resolving whether Mrs. Adedayo's case was or was not an Horizon case, because essentially the Post Office offered no evidence against her and there was nothing for her then to do?
And there had been no submissions before Judge Taylor on that issue which would have allowed her to come to a view.
No, save that I think in the inaudible part of the transcript, it's agreed between the Post Office and Mr. Maloney that what was said was that the Post Office analysis that this was not an Horizon case was not accepted, and he was essentially preserving his position and her position for the future.
Yes.
Thank you. Can we go back to Mr. Thomas's case, please?
Yes.
Can we look in the next step of the chronology at FUJ 0015 2587? And page 5, please. We'd previously been looking at the 10th of March and the 21st of March. We're now looking at the 22nd of March. And if we scroll down a little bit, please, we see Mr. Ward, just scroll up slightly, Mr. Ward emailing the Fujitsu employees that we see set out, confirming in the second paragraph that the Post Office required a witness statement producing ARQ extracts in spreadsheet form relating to Mr. Thomas's Post Office, and a statement explaining the headings and under what circumstances nil transactions can occur. Can you see that in the second paragraph?
Yes.
And then if we scroll up, please, to the top of page 5, we see Miss Lowther providing Mr. Ward with a draft witness statement later that day on the 22nd of March. Please see the draft witness statement for the above re-nil transactions. Does this meet your requirements? And then the page above, please, page 4. A reply from Mr. Ward later that day, the 22nd. In the third paragraph, second line, I'm concerned at the words system failure, which is also in an earlier line. There has been some sort of system failure. What does this mean exactly? And is there any indication of a system failure at this office during the period in question? Can we go forwards, please, to FUJ 0012-2203. And page 3, please. On that day, 22nd of March, Ms. Lowther forwards Graham Ward's email to Mr. Jenkins. Hi, Gareth. Please see reply below from Graham regarding your statement. Ignore the first bit. And then please can you look at his second paragraph and advise with your comments. Again, I've attached a draft copy of your statement. And then if we go up to page 1, please. Reply later the next day, the 23rd. Mr. Jenkins sending a revised witness statement saying, in particular, I don't feel I can include the last 2 paragraphs which may make the statement useless. Can we look at what that attachment was? FUJ 0012-2204. Uh, 23rd of March, draft statement, scroll down, please. You'll see the introduction and then the part of the text in single line spacing. There are 3 main reasons why a zero transaction may be generated as part of the banking system. 1 and 2, and then 3, there has been some sort of system failure. Such failures are normal occurrences. And so the point remains in Mr. Jenkins' statement in this draft, despite Mr. Ward's questions expressed to Ms. Lowther and passed on to Mr. Jenkins. Why is that there? What does it mean?
Yes.
So he's maintaining that reasons why a zero transaction may be generated include some sort of system failure and that they are normal occurrences. Can we go to FUJ 0012-2203? So I'm so sorry. If we can go to the 3rd page of the witness statement, please. And if we scroll down just a little bit, you'll remember that in his covering email, Mr. Jenkins said that I don't think I can say the part in the last 2 paragraphs, and these are the last 2 paragraphs in the statement. No reason to believe the information in the statement is inaccurate. To the best of my knowledge and belief at all times, the computer was operating properly. And then a records declaration. And then Mr. Jenkins said, as well as in his email at the foot of the page, I'm not sure that the yellow bit is true. Can this be deleted? All I've done is interpret the data in spreadsheets that you have emailed me. Just pausing here for the moment, in relation to the page 1 point, system failures being a reason for nil transactions and being normal occurrences in the system, would you agree that it wasn't appropriate for the post office as an investigator or as a prosecutor to insist upon the removal of any references to system failures from Mr. Jenkins' witness statements?
Yes. The emails that we've just seen, I don't think there was anything inappropriate about them asking what he meant by that or asking him to explain that further, but asking him to remove it is a different matter.
To the extent that it was removed subsequently, do you agree that Mr. Jenkins' recognition in this draft of his witness statement that system failures are normal occurrences in the system ought properly to have been disclosed in this prosecution?
Yes.
And in others?
Yes. With more information as to what he meant by that.
And no matter what went on subsequently in terms of the deletion of that line from his witness statement, should that have been material disclosed by Mr. Jenkins himself?
It should, if it was his view, if it was part of his expert assessment, it should have stayed there and formed a part of what he produced.
Do you agree that Mr. Jenkins' request that the last paragraphs, the two that we're looking at, be removed from the draft witness statement ought to have been disclosed in this prosecution?
If the two paragraphs remained in the statement as ultimately served, then the fact that he didn't agree with them clearly needed to be...
I mean, that's what happened. Despite his request for their removal, we'll see that it eventually, in the statement of the 6th of April 2006, those paragraphs remained.
Without qualification?
Yes.
Yeah.
And therefore, his unhappiness at including those two paragraphs in a statement ought properly to have been disclosed in this prosecution.
Yes.
And in other prosecutions?
In any prosecution where this statement was served and or disclosed, or those paragraphs were included in any further statement that was served or disclosed, then his disagreement with them needed to be disclosed as well.
Can we go, please, to FUJ 0012 2210? And just look at the bottom of page 1, please. From Miss Lowther to Mr. Ward. Hi, Graham, please see attached draft, second draft for the above, with further explanation regarding the issues you raised. That second draft is the one that we've just looked at. Please let me know of any amendments as soon as possible, as we need to put this in the post, etc. And then further up on page 1, later the same day on the 24th, Mr. Ward replies at 11:37, Nana, this statement needs more work. I've attached a suggested draft with a number of comments. As mentioned previously, I think that's the previous email that we just looked at, I think the, quote, system failure normal occurrence line is potentially very damaging. It may be worth considering someone from our team taking a statement directly from Gareth. Where's he based? Whilst there's some urgency with this, it's more important to get it right and ensure we're not embarrassed at court, which we certainly could be if we produce the statement accepting, quote, system failures are normal occurrences. Let me know what you think of the draft. And then if we see at the top of the page there, later that day, that's passed, that email directly by Miss Lowther to Gareth Jenkins. Please see email below and the new draft statement. So let's look at Mr. Ward's drafting efforts. Poll 304 7895. If we scroll down, please. And again. And again. And again. And again. No, just, sorry, scroll up a bit more. A little bit more, thank you. Yeah, so this is the relevant paragraph at the top of the page here. There are three, and then Mr. Ward has inserted, if these are the main reasons, what are the rest? Reasons why a zero value transaction may be generated as part of the banking system. And then I think 1 and 2 remain the same. The third reason, system failure, has been deleted. Can you see that?
Yes.
And replaced by Mr. Ward's typing. This is a really poor choice of words, which seems to accept that failures in the system are normal and therefore may well support the postmaster's claim that the system is to blame for the losses for exclamation marks. Do you consider this type of intervention in relation to the content of Mr. Jenkins' evidence to be appropriate conduct by a member of a prosecuting authority?
No.
Do you consider the degree of input into the drafting of Mr. Jenkins' witness statement to be appropriate, if it was the case that Mr. Jenkins was being treated as an expert witness?
No. There was, as I said before, there was no issue with Mr. Ward, as he had in earlier emails, asking what system failures meant and having a better understanding of that, but to take it out because it was embarrassing or damaging or would help the postmaster.
The defendant.
Help the defendant is very much the opposite of what they should have been doing.
Do you agree that to the extent that an investigator or a manager of investigators had made deletions or proposed deletions to a witness statement and had given as a reason that the evidence that the expert was proposing to give might well support the defendant and therefore the words should be deleted, ought to have been disclosed in the prosecution?
Shouldn't have happened, and if it did happen, it should have been disclosed.
Can we go to page 3, please? Can we see that the 2 paragraphs in relation to the operation of the computer, and we'll come back in a moment to exactly what they may have meant, what their focus may have been in a moment, but they have been removed by Mr. Ward.
Yes.
In this draft? Again, was that proper conduct by a member of the prosecuting authority?
It would depend on why it was done and what else was done in relation to it. If clearly, if the person whose statement this was said that they wanted those paragraphs to be deleted because they were wrong, then it was not wrong to delete those paragraphs. But it should have generated discussion as to why they were wrong or what the issue was. And if the issue was, as I read Mr. Jenkins' email to suggest, that for him to attest as to the operation of the system, he needed more material than he had been given, then the discussion needs to be about that rather than just deleting the paragraphs and moving on as if nothing had happened.
Thank you. Can we move on, please, to poll 0012-2217. FUJ 0012-2217. Did I say poll? Yeah. My mistake, I said poll rather than FUJ. FUJ 0012-2217. And can we start with page 2, please? We can see that Mr. Ward's amendments to the second draft of the statement are sent back to Mr. Jenkins. And then if we go up, please. Sorry, up again. Mr. Jenkins emails Mr. Ward directly, copying Miss Lowther in an updated draft statement saying, I've added some further annotations to your annotations. Does this move us forward? So shall we see what the attachment said? FUJ 0012-2218. This is the attachment to that email. Although it was being sent on the 28th of March, the statement remained dated the 24th of March. And if we scroll down, please, and scroll down, and again, and again, and again, and again, and stop, you'll see the third reason, system failures, remains deleted. You'll see Mr. Ward's annotations of really poor choice of words, and you'll see Mr. Jenkins' reply. Please, can you suggest something better then? What we have here are genuine failures of the end-to-end system, which are not part of normal operation, but are anticipated and the system's designed to cope with them. Some such failures could be engineered as part of a malicious attack. That doesn't apply to those failures that appear in the evidence presented. In all cases, the system's designed to identify such failures and handle them in a way that the customer, postmaster, post office, and the financial investigators are all clear as to the status of the transaction, and then any necessary financial reconciliation takes place. I guess one option is to delete over the page the paragraph, since it is purely an introduction to the following more detailed description. So Mr. Jenkins has asked Mr. Ward to suggest something better and raised the possibility of deleting the paragraph. In the light of the fact that Mr. Jenkins recognised in this further draft, or the response to the proposed amendment, do you that system failures were anticipated? Was it appropriate for the Post Office as an investigator or prosecutor to insist upon the removal of the reference to system failures from the witness statement?
No. What was necessary was for them to provide a proper explanation of what that meant.
And the recognition in the text that he added that such system failures were anticipated, do you agree ought properly to have been disclosed in the prosecution?
Yes.
If we go over the page, please. So if we scroll down. You'll see that the system operation paragraphs those two paragraphs at the end that were in the original coloured yellow remain removed.
Yes.
Do you agree that this draft of the witness statement ought properly to have been disclosed in the prosecution?
Yes.
Can we go forward to FUJ 0015 2587? Mr. Ward emails Mr. Pinder, copying Miss Lowther and Mr. Jenkins in, saying, I don't understand why this statement is taking so long to be put together. I appreciate it's slightly unusual, but I don't understand the confusion, as I thought I'd made our requirements clear. Remember the word requirements, if you may. Unfortunately, Gareth's annotations do not take us forward at all. I'm sure this is not Gareth's fault. Gareth indicated in the attachment below that 3 spreadsheets produced by your team were not produced by him, and therefore, as he quite rightly points out, he is not in a position to produce them in his statement. That's a side point. And then scroll down, please. As already stated, we urgently need a statement producing these 3 additional spreadsheets, explaining in general terms under what circumstances nil transactions occur, and in particular how the nil transactions at Garwin occurred. The same statement needs to include a paragraph which states that there is no evidence of a system error at Garwin, assuming this is the case, in relation to nil transactions at the office. We do not need to mention system failures being normal occurrences if there's no evidence of such a problem at this office. It may now be best if the investigator arranges to meet with Gareth to take the statement in person. Do you consider this intervention by Mr. Ward to be appropriate conduct by a member of a prosecuting authority?
No.
Do you consider the degree of input into the drafting of this witness statement to be appropriate?
No.
Ought this exchange to have been disclosed in the prosecution?
Yes. Especially if the statement was being relied upon.
No need to turn them up, but some evidence the inquiry has got, FUJ 0015 5721 and FUJ 0015 2592, suggests that Mr. Pinder of Fujitsu then spoke with Miss Matthews, the investigator, and arranged for her to meet Mr. Jenkins in person on the 6th of April 2006 to, quote, record the statement. And it appears as a result of that meeting, an updated draft witness statement was prepared, dated the 6th of April 2006. If we can look at that, please. FUJ 0012 2237. If we scroll down, please. And again, and again, and again, and again, and keep scrolling, and again. Now, if we just scroll back up, please, you'll see, I think, that the 3 main reasons for nil transactions occurring, including system generated occurrences, do not appear in this final witness statement, nor any reference to system failures at all.
That's right.
But in the last draft, the final draft, the signed version, the 2 paragraphs about the operation of the computer system reappear. Can you see that? There's one on the page there. And then if we scroll to the next page, I think they're just... Yes. No reason to believe the information in this statement is inaccurate because of the improper use of the computer I think they've been combined into a compressed version of both statements.
Yes.
So standing back at the moment from this run of correspondence, would you agree that Mr. Jenkins openly referred to system failure in his original draft of the statement?
Yes.
It was Mr. Ward who objected on behalf of the Post Office to the reference to system failures.
Yes.
Mr. Ward inserted his criticisms of the inclusion of those words into a text of the statement. This is a really poor choice of words.
Yes.
And that it appears to be Mr. Ward who was pressing for the amendment of the statement because Mr. Ward was worried about how system failure might be interpreted and that it might actually help a defendant.
Yes.
Putting aside whether that approach was acceptable, I think you said that each of the versions of the statement ought to have been disclosed, in particular because from 2005 onwards, the CPIA code at paragraph 5.1 required drafts of statements to have been recorded on the unused schedule if they differed materially from the final version.
Yes. And because applying the disclosure test for reasons that Mr. Ward had identified, this was material that undermined the prosecution case and failed to be disclosed anyway.
So the failure to reveal by recording on the schedule the existence of these drafts may be a breach of Section 7 of the CPIA, in that the reference to system failure in the drafts meant that they might reasonably be considered to be capable of undermining the prosecution or assisting the defence.
Yes.
So gathering all of that information together, had the Post Office adhered to the law in relation to disclosure here, then the fact that the witness statement had evolved over time and at whose insistence it had evolved over time would have been revealed to the defence.
Yes.
That can come down, thank you. You tell us in paragraph 213 of your report, which is on page 82, that the snapshot of data that Mr. Jenkins examined in his witness statement was a very restricted one.
Yes.
And that the examination which was undertaken does not appear to have been disclosed, so its limitations were unlikely to have been appreciated by the defence. Having seen now the underlying material and putting aside the fact that the work done reflected, I think, what Mr. Jenkins had been asked to do, do you agree that Mr. Jenkins sought guidance as to whether what he was doing was the correct approach?
I'm not sure I entirely follow that.
Let's look at some other material then. FUJ 0012-2230. And if we scroll down, please. If you just scroll up a little bit. And again. So I think this is an email of the 30th of March between Mr. Jenkins and Mr. Pinder saying, I've taken the data from the peak. Do you recall what peaks were?
No.
You don't? Okay. and carried out my own analysis of it and presented the results in the attached Word document. Hopefully, this is the sort of thing that the Post Office want. If you want to pass it through to them before Thursday, then fine. So the PEAK was an incident management system maintained and operated by Fujitsu that recorded the reporting, investigation and possible escalation of system issues within a certain level of service help desk within Fujitsu.
Yes.
And he says, Mr. Jenkins says, he's taken the data off the PEAK, so from that system.
Yes.
And if we can look, please, at FUJ 0012 2229. This is the attachment to that email that we've just looked at. This note, so it's under Mr. Jenkins' hand. This note is provided as input to a witness statement regarding Garwin. Penny Thomas provided me with extracts from for 3 periods from audited data. I've taken this data and extracted detail of all banking transactions and analysed the zero-value transactions. The following table provides a summary, and then the 3 ARQ periods are set out by reference to the 3 ARQ numbers, 401, 459, and 460, and then scroll down. I've produced a separate spreadsheet, and then he goes on and explains what he's done.
Yes.
So my question, and I cut to the chase too quickly with you, Mr. Atkinson, was that what Mr. Jenkins did was tell Mr. Pinder, this is what I've done, attaching this Word document, and essentially asking, is this correct? Is this what the Post Office want? By saying in his covering email, hopefully, this is what the Post Office want.
Yes.
Can you recall any reply to that? Coming back to him and saying, no, you've done the wrong thing?
I can't recall one, no. And this material does reflect what is in the statement of the 6th of April.
Yes, exactly. Did you see any instruction or guidance to Mr. Jenkins about the retention of working materials such as this, or the disclosure of underlying analysis, the type of which is referred to in this document?
No.
Is that the type of material that should be retained by an expert witness and made available for disclosure?
Yes.
Thank you very much. If we go back to paragraph 213 of your report, which is on page 82.
Yes.
Just wait for that to come up. In paragraph 213, in the middle of the paragraph, can you see a line which says, Mr. Jenkins of Fujitsu does not appear to have been asked to review the underlying data more generally, and then this, but does appear to have provided reassurance as to the integrity of the system, despite that underlying data not being analysed.
Yes.
Are you there referring to that line at the end, or that paragraph at the end, of Mr. Jenkins' witness statement?
Yes.
Can we look at that, please? FUJ 0012 2237. And if we just look at the end of the witness statement, please. And up a little, please. It's that paragraph. There's no reason to believe the information in the statement is inaccurate because of the improper use of the computer. To the best of my knowledge and belief at all material times, the computer was operating properly, or if not, any respect in which it was not operating properly or was out of operation was not such as to affect the information held on it.
Yes.
And this is the abridged version of those two computer operation paragraphs.
Absolutely.
That we saw earlier.
Yes.
And is it the line, to the best of my knowledge and belief, at all material times, the computer was operating properly?
Yes.
That you're referring to?
Yes.
If we go back to the beginning of the statement, please. And if we scroll down, in the second paragraph, you'll see Mr. Jenkins refers to the peak system. Fujitsu have a fault management system called the peak system, which is used for passing faults around the team and tracking faults raised regarding the post office account. And then subsequently, Mr. Jenkins records that he extracted data from the peak system. I extracted data from this system regarding the Garwin post office. And then he says, from this data, I then extracted all the banking transactions which showed a zero value. That's ARQ data.
Yes.
He then produces spreadsheets analysing the existence of or the reasons for the zero values. The statement at the end, if we go to it at the foot of the next page, please. If we keep going, sorry, page 3, bottom. There's no reason to believe that the information in this statement is inaccurate because of improper use of the computer. Was your understanding that the computer that was being referred to was the peak system or the horizon system on which the ARQ data was stored and from which it was obtained, or could you not tell?
My reading was the latter, that it relating to the horizon system, but it's not altogether clear.
So I think you read this paragraph, the abridged version of what is a standard paragraph in other witness statements, as equating to an opinion that Horizon was working properly insofar as it affected the Garwin branch at all relevant times.
Yes.
Rather than that the information in the witness statement refers to information extracted from the peak system.
Rather than that paragraph related just to the peak system. Yes.
Thank you. Can you see that this statement is at least open to interpretation?
Yes.
That can come down, thank you. Before repeal, would you agree that Section 69 of PACE permitted the admission into evidence of a statement contained within a document where that document had been produced by a computer?
Yes.
There was, I think you'll remember, concern that the ambit and effect of Section 69 of the Police and Criminal Evidence Act had been fundamentally misunderstood. Do you remember a case of minors,
Yes.
which you cite in your
Yes.
second report? Was Section 69 in fact only concerned with admission of facts into evidence rather than whether the facts were true?
Yes, it was to do with the operation of the system rather than the truth of the content.
And I don't suppose you can assist us on whether you've explained how you understood that statement as referring to Horizon more generally.
Yes.
You can't assist us as to what Mr. Jenkins' obviously intention was on the basis of the materials that you've seen.
No, although that perhaps underlines why the iterations and evolution of this statement was so important and why its disclosure was so important, because it was that underlying material that would help someone, particularly someone acting on behalf of the defendant, to approach what he meant by this and what his intention was.
And so in circumstances where an investigator, as we've seen the material suggests, took a witness statement from Mr. Jenkins, would you agree that if the witness was asked to include a form of words such as this at the end of their witness statement, it was important that it was made clear to the witness what the words were supposed to indicate?
Yes, particularly where they had expressed reasons as to why its relation to the operation of the Horizon system would not be something that they would sign up to.
Because the witness was saying, I've looked at one computer system, the peak system, I've identified from that some data that I need to look at, 3 lots of ARQ data.
Okay.
I've extracted the 3 lots of ARQ data from Horizon. The computer system was working.
Yes. And
I'm summarising it.
And what I'm not saying is that the Horizon system was operating correctly. That's so that it was clear what this assertion as to correct operation related to and what it equally importantly didn't relate to.
Yes. And so you would agree, I think, that it was important that it should be made clear to the witness what the words were supposed to mean and to which system they were intended to relate.
Yes.
Can we move forwards, please, to FUJ 0015 2616? Can we look at page 3 to start with, please? We've moved on from March and April into the summer. If we scroll down, please. And again, please. Sorry, just scroll up a little bit more. And a little bit more. Yeah, this is an email to Diane Matthews, the investigator of this case, from Mr. Jenkins. At the top of or the bottom of the next page, you will see it's dated the 12th of July. And Mr. Jenkins says, I understand also, second paragraph, that this trial is at Carnarvon. Do you have any idea as to how much time will be involved and exactly what is required? I've never been to court before. I've never been to court in any capacity, and my knowledge of such things is based on films and television, which I'm sure are inaccurate. And then if we go to page 2, please, we scroll up. And again. We can see the reply from Miss Matthews. Just scroll down to her second paragraph. Her third paragraph, rather, which is a reply to the request for for help from Mr. Jenkins. All witnesses will have to be present on the first day unless the defence has agreed their statement and do not wish to ask any questions about that evidence. And then this, it's pretty much as you see on the TV, really. But remember that you will have sight of your statement prior to taking the stand and can only be asked questions specifically about your statement. Was that guidance appropriate?
I'm not altogether sure what it means, but insofar as I understand it, no.
What do you understand it to mean?
Well, I understand it to be saying that the criminal process is like a TV programme, presumably an American TV programme by reference to the stand, and that the witness can only be asked questions about what is already in their witness statement, and I don't know where that comes from, even in America.
Would you agree that that part is positively misleading?
Yes.
Because it's wrong?
Yes.
And would it carry any special relevance in circumstances where a witness had already asked for aspects of their, had already been asked to delete aspects of their witness statement and was now being told by the prosecutor, you can't be asked questions about things outside your witness statement. You'll only be asked questions specifically about your statement.
Yes, I suppose it might have a different message to someone if they understood that the various drafts of their statement had also been disclosed, and therefore questions about their statement might include that, but subject to that, it would tell them that the final draft is all that you're going to be asked about.
Thank you. That can come down. Having reviewed the emails, correspondence and draft statements that we've seen, would you agree with the suggestion that overall the Post Office appeared to seek to harden up Mr. Jenkins' witness statement?
Yes.
And looking at that series of communications and drafts, do you agree that it succeeded in that objective?
Yes.
Do you agree that Mr. Jenkins participated in that enterprise?
Yes.
And I think you've agreed that all of the drafts that we've seen, including observations within the drafts and the communications themselves, ought to have been disclosed.
Yes.
Thank you. Can we turn to the case of Suzanne Palmer, please? You address this in paragraph 229 of your report. Well, in fact, you start at 220, but the bit I want to ask about is 229, which is on page 87. In paragraph 229 on page 87, just wait for it to come up. You comment that prosecuting counsel, Stephen John, provided an advice on evidence which identified a number of lines of inquiry or investigation that he thought should be pursued, but that other than commenting on the particulars of the indictment, he didn't advise on the sufficiency of evidence and say this was another opportunity to review whether there was a proper evidential basis to assert dishonesty was lost.
Yes.
Would you agree that dishonesty as an element of many offences is one which more often than not is proved by inference from the circumstances rather than by direct evidence?
Yes.
Would you agree that if Mr. John, as prosecuting counsel, had taken the view that there was not sufficient evidence to satisfy the first limb of the full code test, he could not have properly continued to prosecute the case?
I'm not sure I altogether follow that. Clearly, if he identified that there was insufficient evidence to prove dishonesty for the purposes of theft, he should have said so. Whether he would have been professionally embarrassed so that he would have to have withdrawn from the case if that advice was not acted on is a separate question. I think not a very clear-cut one.
But put it another way then, given he advised on further lines of inquiry, is it implicit, or can we draw an inference reasonably that he had read all of the papers, he'd considered the evidence in the case, and decided that there was a reasonable prospect of conviction, even if he never said so?
That would be one interpretation, and that might be the right interpretation. It would perhaps to an extent depend on what his instructions asked him to do. Certainly that the standard instructions, such as I have seen them in across these 22 cases, do ask counsel instructed to draft the indictment and to advise on evidence. And where I've seen them, I've seen advices from counsel that firstly say I attach the indictment and why it does or doesn't include, what it does or doesn't include, and a list of further things that are required. The instructions to counsel didn't specifically ask them to advise as to the sufficiency of evidence and whether they agreed that this was a proper case to prosecute or not. So I could see that there may be circumstances where a prosecutor would not understand that's what they're being asked, although I have to say I think they would still be duty bound to do so. But it may also be that those who instruct them were not expecting them to do that, and therefore their failure to do it wouldn't necessarily tell them very much one way or the other.
In fact, we've heard from the lawyers so far that the request to advise on evidence was meant to was intended to encompass a request to advise on evidential sufficiency, not just further lines of inquiry. And the counsel that we've heard from, the only one, Mr. Tapford, has said that he understood the request to advise on evidence to include a requirement to advise on evidential sufficiency. But the vagaries of life at the criminal bar were such that there was often not time to do so.
Certainly, my experience would be that if you were instructed to prosecute a case, you would not just be looking at whether there was a statement from the plan drawer, you would be looking to see whether the case was sustainable or not.
Thank you. Can we turn to the case of Susan Rudkin, please? I've skipped over Josephine Hamilton. And if we can look, please, at paragraph 306 of your report, which is on page 113. In this paragraph, and it's an observation that you make elsewhere in your report too, you say that although the post office may have had evidence of theft or fraud by way of admissions, it did not have sufficient evidence, or at least there had been insufficient consideration of the adequacy of the evidence to prove the level of the loss. This is a point that you make a number of times in the report.
Yes.
Would you agree that the amount of particularised loss in a charge can be relevant to an assessment of whether a prosecution is in the public interest?
Yes.
Any sentencing exercise?
Absolutely.
And confiscation or other ancillary orders?
Yes, both as to whether it's appropriate to do it and certainly as to how much you're asking for.
Would you agree that although there's a requirement to prove that there was a loss for offences of theft, the courts do not generally consider the amount of loss to be a material averment in count on an indictment?
No, that's right.
Because the amount of loss is not a relevant consideration in assessing whether a defendant is guilty or not.
It's not a necessary requirement to establish that, that's right.
And so what's the force of your criticism here then in the light of those points?
That in this case and in such cases where there were questions as to whether there was theft, it was clearly relevant for the investigation to do what it could to identify what it was being said had been taken. And it was necessary for a prosecutor in deciding whether to prosecute to have a sense and an understanding of what had been taken, because it was relevant to the assessment of whether there was a realistic prospect of conviction, but it was also relevant to the assessment of the public interest, and where there was a lack of evidence as to that, it's difficult to see how, without further inquiry, one could go from the beginning to the end of the charging process without at any stage raising that as a concern.
Thank you. Miss Rudkin's case raises issues of post-conviction disclosure as well, which you address in your report. On the previous page, at page 305, at the foot of the page, you say, in the subsequent 2014 review by Cartwright King, the Post Office retained the view there was no evidence of Horizon failings contributing to the loss, and was clearly aware of potential issues with cross-disclosure to other cases. That advice took a concerning approach to post-conviction disclosure, focusing on the consequences of disclosure rather than whether it was required. Can we just look at that,
yes,
please, this concerning approach to post-conviction disclosure? It's poll 3046579. We can see that this is the case of Mr. Rudkin, Mrs. Rudkin's husband. And if we scroll down, please. Analysis. This is written by Harry Bowyer, in-house barrister at Cartwright King. It's the Post Office's firm belief that the major losses suffered by the applicant were caused by theft by his wife. Other minor losses, very minor losses, were likely to have been caused by simple human error. There's no evidence to support the applicant's assertions there were failings with Horizon which contributed to losses at the branch. Unless this position is resolved from, this case should not cause any problems with any Post Office prosecutions past or pending. And then over the page, please. Dangers to Post Office. Second paragraph. If concessions are made that might render this conviction unsafe, then the applicant's wife may well be put in a position whereby she is able to appeal that conviction. Were an appeal to succeed, then the Post Office would be open to a claim for damages and or restitution of monies paid by this appellant under any confiscation order. Such concessions would have to be disclosed to those with similar convictions. This may well necessitate a review of many hundreds of cases to establish who else may be entitled to such disclosure. If concessions are made that might render the sentence imposed manifestly excessive, then the applicant might well be put in a position whereby she might be able to appeal that sentence with similar consequences for Post Office. Again, those concessions would have to be disclosed. And then finally, this is not a case where any concessions can or should be made. To do so has the potential to render her conviction by guilty plea unsafe or her sentence as manifestly excessive, and accordingly invite an application to the Court of Appeal. Are they the paragraphs which you thought indicated a concerning approach to post-conviction disclosure?
Yes.
And can you just explain why, please?
Well, if the position was that there was no material that, and that material had been reviewed, that there was no material following a review that identified any Horizon issues in relation to Mrs. Rudkin's case, then there would be no material that needed to be disclosed and no concession that there were Horizon issues needed to be made, and that would be on a proper assessment of the material. If the reason not to make such a concession was that it might allow a proper appeal against conviction, or it might show that the figure of loss was not, as had been contended, such that the sentence that was imposed was excessive, then that would not be a proper reason to disclose. Indeed, if a concession properly would allow for an appeal to be advanced, then that would be a reason to disclose it rather than not. If the reason for not making a concession in one case was its impact on others, where that was a concession that was rightly to be made, then that's not a reason not to make it. And so my concern was, looking at this document overall, it was not clear to me as the final assessment whether it was being assessed here that there was nothing that needed to be conceded, or that there were reasons of impact why they didn't want to concede it.
Can we look, please, at another example? This involves Lynette Hutchins, whilst we're looking at post-conviction disclosure. Poll 0006 0715. This is addressed 435 to 436 in your report, Mr.
Thank you.
So poll 0006 0715. This is an advice written by Simon Clark of Cartwright King. And if we just scroll through it, please. The offence is set out, the case history is described. If we carry on through the case history and over the page, it sets out the prosecution case. If we continue, and continue, please, and keep going. And then discussion. Defendants unequivocally admitted making false entries into Horizon. In the belief that the balances would be corrected in the fullness of time. She stated in her prepared statement she didn't do so dishonestly. Had she chosen to advance that account at trial, the jury would have been entitled to accept what she said and to acquit her, or to reject her account or convict her. Thus, the opportunity was there for her to seek an acquittal. Over the page. There's a discussion about Eden in paragraphs 11 and 12. 13 addresses the defence statement, and then 14 addresses conviction. Mr. Clark says it's not the purpose of this review, nor of the review process overall, to determine whether or not any particular conviction is unsafe. That decision is reserved to the Court of Appeal only. The purpose of this process is to identify those cases where the material contained in the second sight interim report would have met the test for disclosure as provided by the CPIA, the Code of Practice enacted thereunder, and the AG's guidelines on disclosure, had that material been known to Post Office Limited during the currency of the prosecution, and accordingly would or ought to have been disclosed to the defence. And then over the page. In this case, I advise, given the chronology and circumstances of the guilty plea, the reference in the basis of plea to the leading case on the topic, and the second sight report and the Helen Rose report would not have been disclosable during the currency of the prosecution, and accordingly do not now fall to be disclosed. Had we possessed the material at the relevant time, we would not have disclosed it to the defence. Why do you say that this misunderstands the disclosure test?
It proceeds on the basis that there was a guilty plea. She, Miss Hutchins, could have contested this matter at trial. She chose not to. She had legal advice, so that's down to her. It doesn't recognise that there was a stage before Mrs. Hutchins was arraigned, and it was at that stage that the question should have been asked as to whether there was material that was capable of undermining the prosecution case or assisting hers that ought to have been disclosed. And this is all concerning, as I read it, that the second sight review and the issues that it gave rise to as to whether the operation of Horizon and material relating to the operation of Horizon had been properly appreciated and or disclosed. And to say we don't need to worry about this because she pleaded is to ignore the fact that there should have been disclosure before she had the opportunity to. To say there's a reference in her basis of plea to Eden, therefore she was clearly advised by counsel, ignores the fact that counsel had not had this material disclosed to them either, and a failure to recognise that it was at least possible that counsel told that the basis for the prosecution case was susceptible to challenge, may have given different advice to his client to one who was not told that, and also that in relation to any appeal against sentence that was potentially available, and or to submissions that could be made to a judge before sentence, issues as to the operation of the system and confirmation of those issues by the prosecution would have been of assistance to the defendant. It is a different thing for a judge to consider a case where the explanation is given that this was inadvertent rather than anything deliberately by the defendant on the one hand, and to have that confirmed by the prosecution on the other.
At that time, and indeed today, the leading decision, in fact the operative decision on post-conviction disclosure obligations was that of the Supreme Court in Nunn.
Yes.
And the decision was reflected in the then Attorney General's guidelines on disclosure at paragraphs 59 and 60, the acid test being whether there presently existed information which might cast doubt upon the safety of the conviction.
Yes.
And that test is to be applied, if I got this right, irrespective of whether there was a plea or not. It's material that might cast doubt on the safety of the conviction,
yes,
however the conviction was obtained.
Yes.
And overall then, in these two cases, when you describe the approach to post-conviction disclosure as being in the one case concerning and in the other case involving a fundamental misunderstanding of the test to apply, are you saying that the approach that was being taken was inconsistent with the law?
Yes.
Thank you. So we're about to move to another case study, that of Peter Holmes. It's 1 o'clock. Might we break until 2, please?
Of course.